County Small Business Source Program. Just trying to wait and see, are we kind of solid with the numbers, Mercedes?
I think we're holding steady for now, and I did just start the recording as well.
All right, thanks so much. Again, welcome to today's Wednesday webinar with the Cook County Small Business Source and our business service organization partner, the Illinois Restaurant Association. As we go forth in what we call our Wednesday webinar series, we've been hosting these for over a year now, and they're always on the fourth Wednesday of every month. So if you would like to join us, you can check back in next month. You can also find our previously recorded webinars on our YouTube page as well. So let's get started. So the Cook County Small Business Source Program, I'm going to give you a brief overview of who we are and what we do, and then I'm going to hand it over to Teresa from the Illinois Restaurant Association and also our wonderful speakers. I also have Mercedes McClure, who is also one of my wonderful colleagues here from the Bureau of Economic Development in Cook County. She's assisting me and all of us today with the webinar. She'll be going through our questions and if we have any tech support issues as well. Mercedes, did you want to say anything?
No, just it's very amazing to have everyone on the call today. And we do host these webinar Wednesdays, the final Wednesday of each month. So we're very much looking forward to having a variety of topics and collaborators this year.
That's great. Oh, we also have Valeria. Thank you, Valeria. I didn't know you were on the call. Valeria is also our wonderful colleague here at the Cook County Small Business where she's also assisting. So if you all have any questions, please hold our questions and drop them in the chat. And Mercedes and Valeria will be in there answering them for you as well as giving the questions to our presenters. Okay. So if you are not familiar with the source is a no-cost business advising resource as well as small business resource hub for the small businesses throughout Cook County. We provide free one-on-one business coaching. We provide, again, free resources. You can go to our website. We have a resource library where you can access templates and tools to assist you with uplifting and elevating your business. And we have free events such as this, as our Wednesday webinar, as well as other events that our BSO organizations, referral partner organizations are hosting all, I'm going to keep saying free, that's our free plug, that you all can lock into to help you with scaling your business, whether it's in marketing, whether it's in tax help, how to use AI to uplift your business. This wonderful webinar that we're hosting, everything that we offer here through the source is free. Again, I know a lot of people don't believe that, so I keep saying free just to make sure you're hearing it in your head and it clicks, okay? We also offer free, well, not free, we do also access to capital opportunities. We have a funding page that we do keep updated. You can go to that page if you're looking for funding opportunities for your business. Valeria is really great with finding opportunities and dropping them on their page for anything we see through the state, the city, Cook County, different partner private organizations, grants, might be some loan opportunities, different things that you all might be able to utilize for your business. Also, within the coaching, people say, what do you offer with that? Within coaching services, we do anything from small business startup, emerging businesses, established businesses. We do help with marketing strategies, food certifications, accounting, QuickBooks. Again, I told you we had a wonderful webinar on how to use AI for your business. We did one on how to build a website, legal assistance, marketing support, everything that you see here on this slide. For access to capital, we do offer financial literacy cohorts as well through our partner organizations, financial management, access to capital. We are trying to make sure that we're getting you as a business owner grant ready. We do have grants coming out. Other organizations have grants coming out. And with us finding that a lot of businesses have not, who are starting through COVID, during COVID, before COVID, a lot of foundational things were not done. So we are taking a step back and scaling you all up. So when these opportunities come, you are ready and have every opportunity to access and get that assistance that you need. How do we do this? So I need to change this slide because as of a few weeks ago, we brought on two new BSO partners who are not listed here, but which will be Chinese Mutual Aid as well as Builders Avenue, who will be assisting us in our solar space. We have a new program called Solar Synergy that is now going to be partnering with the source. So if you or someone you know are starting a business in construction and solar and would like to, dive a little bit more, learn a little bit more, you can tap into the source. We do have assistance in that area as well. But here are our BSO, we call them business support organizations, who help us with providing all those free resources that I just talked about. I'm not going to list them all. You see them here. Illinois Restaurant Association, who is our partner for this webinar Wednesday, is a great partner for us. If you are in the restaurant catering space, definitely tap into them. We have WBDC, Allies, Greater Southwest, Rogers Park. This is just makes up a few of our partnership model who assist in providing those free events, resources, trainings, cohorts, and the like that you all can tap into for whatever your business may have a need of. This model here is just a broader scope. We also have what we call as referral partners. We have over 40 referral partners typically. I think on this one we have like 36 or something. These referral partners are small business organizations that are located throughout Cook County. I always tell people, feel free, please take a picture. These are your community organizations that are located right around the areas in which you live. So if you need direct assistance and help in any other areas, these organizations do help drive businesses to the source. Some do not provide one-on-one coaching, so they do send people to the source to get that coaching that they may need. But they do might have tapped into different access and avenues for access to capital and things like that if they're chambers. We have Hire 360, another cohort organization who taps into the solar space. Hycia Elevate, eLocal Marketplace, Des Plaines Chamber, Oak Park River Forest, Northwest Side Community Development Corporation. So we're really trying to make sure that we're providing access and opportunity to all small businesses throughout Cook County. We're making sure that everyone is getting the assistance that they need. Everyone has access to these opportunities. And with that, our numbers have grown significantly. So as you can see here, since our inception of this program was started during COVID, of us seeing the need and trying to keep businesses running in 2020. Now we're scaling businesses up in 2025. So we have distributed over $60 million in grants. We have assisted over 24,000 businesses through advising as direct business coaching, advising and events. And we have touched and reached over 106 plus thousand businesses by way of us doing door knocking, phone banking, e-blast sales, the like. This is how many businesses we've touched through that reach. As you can see, our demographic numbers here, we have worked with over 82% of our business owner identify as business owners of color. 59% are identifying as women-owned businesses. That number is going down just a little. We used to be steady over 62 to 65. We see it's going down now. 94% are micro businesses, meaning we work typically with businesses or 10 or less employees. As you can see, I'm not going to go through the other side. That's just a broader breakdown of the race and ethnicity of groups that we work with within the source. And again, I said we are very diverse. We're trying to help everyone, and our numbers are showing, and we are very excited with the work that we're doing here. I'm not sure if you are familiar with the Source Grant in 2023. We distributed a $50 million grant award that was able to assist over 3,000 businesses. We dispersed a $10,000 grant as well as a $20,000 grant. All of those businesses were micro businesses and had over 20 or fewer employees. So really excited. Stay connected with us. We are currently preparing a new grant that will be dropping soon within the next couple of months, within the summer months. So log in if you want to tap in and make sure you don't miss it. If you're not connected to our newsletter, make sure you're connected. If you know business owners who are not, make sure they're connected. Everything we send out as far as information is typically through our newsletter, e-blast, and or social sites. So connect with us in those aspects and you won't miss any upcoming information. And these are just some of our source grant winners. I just like to show a good picture to see real people who are being helped and not just the numbers. So they're all excited. They're here with President Winkle, with some of the commissioners, as well as our BSOs, and they're very excited that they got a grant. Who wouldn't? It's $10,000, $20,000. And here are some other real people that we have assisted through the source. These are not grant winners. These are actually real business owners who have been helped through the Cook County Small Business Source. So one worked with was it Southland Development? This is Berwyn Development. If you have not seen a Berwyn shop, definitely check them out. And Miss PSG Free, I'm not sure. She is all over my social media. So if you all haven't seen her, she is really blowing up. Miss Latrice is blowing up. She just opened her second venture here. I think it was Crabs and Cocktails. She just changed the name. I forgot the name. But we're doing great things. We're helping everyone who needs the assistance. So if you need any assistance, we would love to help you. And this is how you can log in with the source if you're not already. If you're working with Teresa, great. If you know anyone, you can direct them here to cookcountysmallbiz.org. We can get them into the intake form, get them signed up to work with one of our advisors. Again, if you would like to sign up for our newsletter, go down to the bottom of that website. If you go to our business advising page, you see here, the big red circle is how you can get into our newsletter as well as our e-blast. So look forward to working with you all. I thank you all again for joining us. I'm going to transition it over to Teresa of the IRA and let her introduce the speakers that we have joining us today. Thank you all so much. And Teresa, I am going to hand it over to you, and I'm going to stop sharing now. Thanks so much.
Wow, thank you, Dominique. So thanks everyone for being here today. I'm going to keep this super short so we can jump into it. My name's Teresa Crisanti with the Illinois Restaurant Association. And today we're going to talk about employer rights and in the immigration workspace. So without further, you can also post your questions in the chat function and we will hold a Q&A at the end of this presentation. Without further ado, I'd like to introduce Connor Gallivan with the American Business Immigration Coalition, Amiel Harper, General Counsel, Color Hospitality Group, and Michael Jarecki, Principal, Jarecki Law Group. Guys, please take it away.
All right, thank you so much, Teresa. Hello, everyone. Again, my name is Connor Gallivan. I'm with the American Business Immigration Coalition. And for those who are not familiar with us, we're a bipartisan coalition of over 1,700 employers who are organizing around common sense immigration solutions. However, we're here today to discuss what to do in the event of potential DHS enforcement actions and what are the rights and responsibilities of employers. So give me a moment. I'm just going to share my screen here. So, what can we do to navigate the changing immigration landscape to make sure that we are keeping ourselves, our businesses, and our employees safe? First thing I want to say here is it's important to stay right at the top of the call. This is not legal advice. I am not actually an attorney. We are joined with some attorneys, and this presentation was put together with the support of attorneys, but every case is different. So, we would really suggest that you consult with a qualified attorney regarding your own case if anything does come up. The goal for this presentation, pretty simple. We would like to give employers guidance to minimize the disruptions to workforce and their day-to-day operations. To do this, we're going to be covering the primary ways, or at least the primary methods that DHS has at their disposal to reach out to your business, and those typically take the forms of either I-9 audits, workplace raids, Social Security no-match letters. We will also be covering what to do to make sure that you can preemptively protect yourself by doing a self-audit of your own I-9s, as well as working with your employees to make a company-wide worksite raid plan. So, to start off, what are DHS's primary tools at their disposal? Well, first and foremost, they have the ability to audit your I-9s. This is when they'll request to review an employer's I-9 forms and basically just to see if there are any discrepancies in it. The repercussions here, if there are problems, typically only take the form of fines. And for some cases, you could be required to enroll in E-Verify. The other tool they have at their disposal is a worksite raid. This is when ICE agents will arrive at your worksite unannounced with the intention of trying to either detain or arrest any individuals that they believe to be in the US without proper authorization. To kick things off first, what do we do in the event of a Social Security no-match letter? This is essentially what happens when DHS finds some discrepancies in the information that they are receiving from the I-9 applications. It's really, really easy here. When you receive this letter, it will actually clearly state exactly what DHS needs you to do and what sorts of paperwork you may need to refile in order to resolve this issue. The important thing to really understand about receiving a Social Security no-match letter is what you shouldn't do. And that's take adverse action against an employee simply for receiving it. The reason for this being is this could actually violate some labor laws and, not something we all really ever want to do. In addition to that, it could also violate the civil rights of these employees, which again, not something we want to encourage. The information that you receive from an SSA mismatch record or E-Verified does not actually make any statement regarding that worker's potential immigration status. It's only that there have been some issues in the I-9 application itself. However, we can get around some of that by actually just doing some self-I-9 audits on our own. This is probably one of the best things that you can do as an employer just to make sure that you can protect yourself from any future DHS enforcement actions. It's really easy and it's something that we've been encouraging everybody to do. The way we do this, a couple things to remember here though is if you are audited, you do not have to pass over any documentation for at least 72 hours. This is the standard rule of thumb. This should give you enough time to make any corrections that need to be made on I-9s to make sure that you gather all of your paperwork, as well as reaching out to employees who may also need to get involved by making some of the corrections on the I-9 applications that they've submitted to you. The next thing that you want to do if you are audited by I-9 is you want to contact your employment immigration attorney immediately. The sooner that you let them know that there is something going on, the sooner that they can start working with you to give you some advice about the best way to make sure that you are going to be above board and that you are going to keep everybody protected. The other thing, another couple of things that we would always suggest to people if they are audited, to please only ever turn over the files that are requested. We've seen in the past, some people will, if they have an employee that is being audited or a few I-9s that are being audited, they will pass over all the I-9s that they have in their, that they have available to them, just as a way to show good faith. We actually wouldn't suggest doing this. It's really helpful for you to only submit over the documents that DHS is requesting to review. On top of that, it's a great idea to make sure that you keep copies of any of the documents that you hand over to ICE, just to make sure that there's no discrepancy in what you believe you handed over and what they say they received. On top of that, it's really important to make sure that you only keep I-9s for as long as you're actually required to. So the basic retention rule is for how long you should keep an I-9 is either 3 years after the start date of employment or 1 full calendar year after that employee's last day of work for pay. You want to choose whichever one of these options happened later. Moving forward, how can we actually make corrections on I-9s if we are audited and or if we want to do a self-audit of our own? Well, what you're looking at here is section 1 of an I-9 application. This is the section that an employee must fill out before their first day of work for pay. It's first of all really important that they fill this section out before their first day of work for pay. They don't have to do it the exact same day that they start. They could do it earlier, but they cannot start employment without first filling out this section of the I-9. It's also important that you make sure that it is the employee themselves that actually fills this section out. This is not a section that a manager can, essentially help you with. An employee specifically needs to be the one that does it. What you're looking at right here is a properly filled out a section 1 of an I-9 application with every single piece of information written the way it's supposed to be written. The reason why it's so critical that you make sure that every single section here is filled out properly is because there are issues. You could potentially face fines for every single individual error that happens on this document. We'll talk about the fines that people could face a little bit later, but just know that every single time there is a single mistake, that is eligible for a fine. Meaning if, say, for example, an employee forgot to put in their street address, ding, that's a fine. If they forgot to put in their street address and their social security number, ding, ding, that's 2 fines. So as you can see, these can add up really quickly here. So just make sure that you take the time to review, section 1 when an employee returns it, and make sure that everything here is filled out properly. A couple quick tips. You don't actually need to have the employee email address or employee telephone number. That's basically the only section of this is kind of optional. However, we would always suggest that you do make sure that you get this information, just in the event that you have to reach back out to that employee for, any changes that need to be made in the future. On top of that, one of the most common mistakes that we do see in section 1 is actually the date of birth. In a lot of cultures around the world, it's common to write a date of birth or dates in general in a day, month, year format. But in an I-9 application, it's critical that it's written in the month, day, year format. One of those little mistakes that are totally honest and people make all the time, pardon me, but could result in having a fine be put against you. Section 2, this is for the employer or manager to fill out, and it has to be filled out within 3 days of that employee's first day of work for pay. This is the section that is used to basically verify the employee's identity as well as workforce authorization. And it's where, you will ask an employee to submit documentation for you that prove these things, and you will have an employer or manager copy in the information from the documents that employee gives to you, and then list it right in this section here. Now, Section A is a document that is going to prove both an individual's identity as well as workforce status, employment status. A common example of this would be something like a passport, whereas list B and C are 2 separate documents, one that proves identity, one that proves workforce authorization. When you're asking an employee to provide this documentation to you, it's important to remember that you cannot specify which documents they would like to provide. If they only want to provide a document from list A, you have to allow them to provide that document from list A. If they opt to providing a document B and document C list item, then you have to allow them to use that document B and document C list. It is totally up to the employees, as to which information they would like to present here. A couple other things that we would always make sure to suggest to everyone. It's really, really helpful to keep a copy of the documents that employees present to you, but there are some rules around it. More specifically, you cannot pick and choose individual employees that you want to keep a record of the documents. You either have to keep a record of everyone, or you have to keep a record of no one. That being said, if you at some point, if in the past you have not actually been, saving copies of your employees' documentation, and you would like to start doing so now, you can start doing so now without any repercussions. You just have to make sure that you continuously save documentation for any and all future employees moving forward. Another thing to mention here is you cannot retroactively go back and ask employees who have already filled this section out, they've already submitted their I-9, to resubmit the documentation they provided to you so that you can save a copy of it. It's kind of a, once it's submitted, it's done, you kind of have to move on. So, please know that you cannot ask an employee like, hey, you started a few months ago, we want to get a copy of your, say, for example, passport. You can't do that. A couple other things to mention here is you want to make sure that the information about the employee is consistent with the information that they provided in Section 1. You want to make sure that in Section 2 about employee's identity and employment authorization is consistent with the documents they provided, and you must review the original identity and work authorization documents. You know, you can't just accept a picture, for example, of an ID. You have to see the actual physical ID itself. What you're seeing here is a list of some of the available documents that employees have the option to submit to you when they're, you know, filling out an I-9 application. And again, it's either going to be one item from list A or one item from list B and one item from list C. You can get a full list if you go to the USCIS website and navigate to the page where you download an I-9 application. It should be in every single I-9 application. It's also really helpful to make sure that when we give the I-9 application to your employees, you give them a copy of this document too, so they know what to bring. But yeah. Next up, we have what to do in the event of re-verification or rehiring. So this is supplement B essentially, where an employer or manager should complete this section, which is section 3, when an employee's employment authorization documentation has expired. This would include people who are returning or a rehire of any kind, things such as like a H2A, H2B, etc. Big thing to note here is that not all expiring documents require actually review. If the employment authorization document has expired, you want to ask the employee to present the new qualifying document. And this is typically something either you choose a list A document or you can choose a list C document. You don't actually need to collect another list B document if they've already, you know, been hired in the past, because you've already verified their identity. They've already provided that documentation over to you. What you're looking for here is to verify their work authorization. That's the thing that list C documents do. That is what a list A document will do. And again here, who fills this out is important. It has to be the employer or manager that does this section. And again, you know, like everything else, you want to make sure that any and all information is consistent with every other section of the I-9 application, as well as any documentation that your employees are giving over to you. Now, all this being said, you know, there are going to be mistakes that happen. That being said, it is totally okay to make corrections on an I-9 form, even if you are audited. You know, this is why it's important to take that full 72-hour window that you have at your disposal, just to make sure that you take all the time to review documents and to make sure that you can correct any of the errors. That being said, you know, but with that, how do we make these errors? Well, it's really simple. If there is a mistake on an I-9 document, what you want to do is just draw a simple line through that mistake, write the correct information above it, and then have the person who's making that correction sign an initial right by that correction. You do not want to do something like scribble out the mistake all the way, or take a big permanent marker and drive a line through it, or use, you know, especially you do not want to use whiteout fluid. You just want to do that simple line, that simple strike through, write the correct information at the top or right above it, and then have the person making that correction initial and date where that correction was made. The other important thing to remember here is who is making this correction is also important. If it's an error on section 1, the portion that employees were supposed to fill out, it has to be the employee themselves that makes that correction. However, if the error is in section 2, what an employer or a manager fills out, that correction has to be made by the employer themselves. Really, really important to make sure that, you know, that the person correcting that form is the right person to be correcting it. Now, all this to say, and why we keep going on about all the mistakes that happen, well, as you can see, there are consequences for not being compliant with a Form I-9. And, you know, what you can see on the screen here is these fines can get pretty hefty. Now, if you're seeing maybe 1 or 2 errors, you could be hit with something like a $676 fine per an infraction. But if it's found that an employer is maliciously making a lot of mistakes, or it seems to be they are intentionally working to hire almost exclusively undocumented people, or not reviewing documentation, basically it looks as though they are being more malicious, these fines could go up to as high as $27,000 per an infraction, per a violation. So when I talked earlier about, you know, If an employee gets their address wrong, ding, that's a fine. That could be a $676 fine. If they get their address and their social security number wrong, that's two $676 fines. So as you can see, it adds up quite quickly. So it's really helpful just to make sure that you make sure that you coach your employers and your managers on how to make sure that their employees are filling out the I-9 applications, and that you take the time to review the I-9s when you receive them, as well as to do a self-audit, ideally as soon as possible. Next up, we want to talk about what to do in the event of an ICE raid. The number one thing that you want to do is make sure that you have a point person. This is the person that and ideally you want to have one point person per shift per site. This is the person and the only person that should be engaging with ICE agents in the event of a work site raid. And their job is pretty simple. You want them to be responsible for confirming whether or not ICE has a judicial warrant. You want to make sure that that this point person is the only one communicating with the agents, as well as this point person has the contact information for both the employer or management of this business or company, as well as the contact information for your company's legal counsel. That way, the point person can let you all know, as well as get on the phone with a lawyer as quickly as possible, just to make sure that everyone is aware of exactly what's happening. The other really critical thing that you need your point person to do is to make sure that they are responsible for recording the badge numbers or agent names. We actually suggest trying to get both, and keeping an accurate record of every single thing that happens during the entire raid. They should be able to keep really detailed notes, or if it's possible, be able to pull out a phone and actually record the raid as it's in progress. This is helpful because you will be able to share this with your attorney, give them more information to help build a better case to protect you, your employees, and your business. Now, another important thing that your point person needs to know is to understand the differences between an administrative and judicial warrant, and what these two different kinds of warrants give agents the authority to do. Now, for the sake of DHS enforcement actions, the really critical warrant to understand is the judicial warrant signed by a federal judge. This is the only warrant that would give ICE officers the ability to enter in your place of business without your expressed permission. If they do not have a judicial warrant signed by a federal judge, you do not need to open the door. You do not need to work with them. You do not need to do any of the things that they are asking. On top of that, on a judicial warrant, it will actually clearly indicate, and you can see it's the one on the right here in the top left-hand corner. It will typically outline exactly what this judicial warrant is giving the ICE agents the authority to do. It should list the company's address, any of the spaces that this company or business has that ICE agents wants to investigate, as well as listing the specific names of the employees that they want to investigate. That's another really critical part too. When agents are hoping to speak to your employees, they have to have a judicial warrant that specifically names the individual employees that they want to communicate with. If they do not have that employee's name written in this judicial warrant, that employee is not going to be required to talk to them. Now, on the left-hand side, we have an administrative warrant. This does give ICE agents the authority to do things like make arrests or detentions, but it does not actually give them the authority to enter in a workplace or a home, for that matter, without the expressed consent of the owner or manager or whoever. When agents show up, the first thing you want to do is you want to ask them, do you have a warrant? Do you have a judicial warrant? And you want to make sure that you get the chance to see this warrant. If you see the administrative warrant, it's okay to let them know that this is not a judicial warrant. Please come back when you have a judicial warrant. Other times you might come into circumstances where you ask an ICE agent if they have a warrant. They might say yes, and kind of hope that you don't know the difference between an administrative and a judicial warrant, and attempt to essentially play it off as though they have the same authority that a judicial warrant would give them. That's not the case. That's why it's important to really just make sure that they have the correct warrant, that they have the judicial warrant, and that it is in fact signed by a federal judge. Next up, let's talk about the work site raid itself. Well, the number one thing you want to do, in the event that this raid is actually happening, is confirm whether ICE has the judicial warrant. Next up, you want to make sure that the scope of that warrant and only the scope of that warrant is being followed. You want to ensure that the agents are following the law by only opening up areas that are legally authorized to enter. You want to designate a point person to be the only person to communicate with ICE. And a really, really important one here is you want to be truthful and you do not want to interfere with ICE activities. You don't want to do anything that would escalate the situation. Sometimes, you might come across a situation where people are going to be in distress, employees are scared, they might want to leave the facility, they might not want to, engage with the ICE officers despite the fact that their name is listed in a judicial warrant. You do not want to interfere at all. You do not want to get involved. It will not be helpful for you or your employees. On top of that, there, have been circumstances where agents have, gone outside of the scopes of the warrants that they produce. They maybe are doing things that they don't actually have the legal authority to do. If this is something that happens, you do not want to try to fight them in the moment. You don't want to, say, for example, physically try to stop them, right? The best place to protect yourself, the best place to fight back is always going to be in the courtroom. So really make sure that you just keep a strong record of every single thing that happened during this raid, that you got a copy of the warrant, that you were able to, show your lawyer exactly what that warrant gave them, and explain to your lawyer exactly what happened during the event of that raid. On top of that, for third-party work sites and contractors, what you want to do in the event of a raid is to direct agents to contact the company itself. You want to make sure that staffing companies, same virtue here, are also confirming their compliance with any applicable law in writing to your company. What's the action plan itself? Well, what do you want to do? You want to ask to see a warrant and request that ICE come back with a warrant if they do not have one. You want to request a warrant before handing over a specific employee. Again, really important. It would have to, list the full name of the employee that they're hoping to investigate. You want to make sure that you speak with and are represented by an attorney. You want to remain silent and wait to sign any paperwork until after consulting with your attorney. This is another big one. You might sometimes get pressured into trying to sign something. You do not have to sign that until you've had a chance to speak with your attorney. On top of that, you want to take the full amount of time to gather requested documents to ensure you are handing over only the requested documents. And on top of that, it is okay to request more time. So that's that 72-hour window. You are actually allowed to request to have more time. It will not make you look bad. They might not necessarily say yes, but what we've typically seen is DHS is pretty lenient with folks when they do ask to have an extension for how much time they have to request to return, to hand over, I should say, requested documents. We typically see them going, up to a week or up to a full work week. Last but not least, you want to ask the agents to identify themselves with either a name or badge number, but preferably both. And I think here I'm going to go ahead and pass over to Michael.
Hi, my name is Michael Jarecki of Jarecki Law Group. We're a full-service U.S. immigration law firm. We definitely help employers in audits of I-9s, representing them before Homeland Security investigations when there is an audit, making sure that they understand which documents are valid for I-9 compliance. But the other side of the coin is we oftentimes get contacted by employers where they are doing an audit and they've discovered that maybe a trusted long-term employee may not actually be work authorized or may have used documents that are not the real identity documents of the individual. Or there's an audit and either through Social Security no-match letters or no matches through Homeland Security investigation, there's a list of employees where the government wants the employer to re-verify, ask for re-verification of those individuals so that they could be compliant with I-9. And oftentimes that sort of means those individuals may have used identity documents or work authorization documents that are not real or of somebody else's identity, and they get an opportunity before any action is taken to terminate them to correct that in case there's an error. And oftentimes there isn't a correction available, so those employees will either be terminated or will not show back up to work. So oftentimes employers say, gosh, I want to comply with the law, but I've had a long-term relationship with this person and I would like them to be on the best footing possible. And oftentimes employers can share resources with employees or former employees, and that's really the best that you can do for them, because obviously this puts their world upside down. They don't know which direction to move in, and we don't want them to run into a bad situation where somebody's going to prey on them, take a lot of their money, even though there might not be an actual legal fix for the situation that they're in, yet they should have access to really well-qualified immigration counsel. So to that end, you could distribute Know Your Rights materials to those individuals, or you could make them available on a bulletin board now in case anybody wants to access that information on an ongoing basis, or they have a family member or a community member who could use the information. A lot of times individuals are in mixed status families, so this information can be really powerful for the people that they're around and the people that they care about and love. These Know Your Rights materials include what to do if you're questioned by an immigration law enforcement action, what to do if you want to have power of attorney for property or guardianship of your children, because in the morning you drop off your children, in the afternoon, if you're stopped or detained by ICE, what's going to happen with your children? And there's many other documents there that could be useful to individuals in that situation. After an audit, one of the things that employers can do is make a list of trusted immigration attorneys available to employees. You could source that through your current employment-based immigration attorney. You can source that through other trusted sources. And then maybe you have a list of several there that maybe speak a language of choice that's a majority language other than English for your workforce. And in that way, individuals can get the information. And I've often seen employers offer to pay the initial consultation with the lawyer. Just because the employer pays the consultation, that doesn't disturb the attorney-client relationship that the client or potential client will have with the attorney. So one person can pay, but the attorney-client relationship can be between the attorney and the consulting individual. And that's very important to avoid conflicts of interests. You don't want your employment-based attorney who represents your interests doing consultations with your employees, because if they learn of information and they share that with you, and you have constructive knowledge of somebody's status not being work authorized, then you are obligated under the law to take action on that knowledge that you've acquired. So that's a super important point. Also, next slide. Just want to mention that since January 20th, things are moving at the speed of light. Things are going so fast. Policies are changing. Obviously, presentations like this are going to be vitally important for you to stay abreast of these changes because they are happening so quickly. And there have been an influx of people who have had work authorization in the United States through various parole programs, because people have come in and claimed asylum, and after 150 days, they were able to get a legal work authorization card. Uniting for Ukraine parole is another way that people came in. Temporary protected status is another way that people have been able to maintain the color of law in the United States as well as get work authorization. But unfortunately, at the tail end of the Biden administration, the Secretary of Homeland Security advanced some of these to allow for additional work authorization into 2025 and 2026 and beyond. Now we're seeing the current Department of Homeland Security scale those back and reverse those orders. So you really have to pay attention to the law and to some of the US Citizenship and Immigration Services information about when a work authorization is going to expire or not, especially for those of you who have had the experience where an employee may have a work authorization card that expired. You asked them to re-verify and they brought you a piece of paper with the I-765 notice, and that paper allowed them to extend for 540 days or extend for 180 days. So that's kind of all on its head right now. And the best thing you can do is either educate yourself or reach out to your employment-based immigration attorney who can give you the hard and fast information so that you know that individuals are maintaining work authorization if they've re-verified or if they're coming to you with documentation on the first instance. To that point, I just want to mention, based on what Connor talked about, the I-9 compliance and administration of the I-9 document is deceptively easy, but it could create a lot of headaches for an employer, including financially, if it's not done correctly. So it's really important to have the procedures in place as to who's administering the I-9s, and have trainings for those individuals, especially when things are changing in the ways that they're changing, and oversight. So you don't want each individual hiring manager in your company being responsible for I-9, especially if there's not training, because then you're going to see as many people completing the I-9s, you're going to have those many variations and more of how they're completed. So you really want to have one standard practice in place. And if you could limit the number of people doing your I-9 initial documentation as well as the audit, that's going to create more consistency. There is a really good document called the M274. That's put out by U.S. Citizenship and Immigration Services, which is basically a manual for all I-9 questions. That talks about completing I-9s, what types of documentation are valid, how to put in certain documentation, whether that's in A, B, or C. And that's a really, really good tool for any employer to use to reference some of the changes that happen, because they're constantly updating that manual to be a really good solid resource for employers going through this process. So staying informed is super important. I know we're short on time. I definitely have more to say. I want to turn it over to Amiel to see if he has any comments, and then maybe we'll take some questions.
So my name's Amiel Harper. I'm the general counsel for Color Hospitality Group. The most important thing, I think, from the employer's perspective is to keep consistency in what you do, and also to make sure that you have resources available for excuse me, for your employees outside of your company. So making sure that they have things available for them, like Michael mentioned, the know your rights information. We think it's a great thing to have attorneys kind of planned and on call for them to have an initial consult with, or at least a recommendation, but also to have, we literally created a checklist for what to do if ICE or Department of Homeland Security shows up. And that checklist is actually at our host stand, so that every individual who comes to us and every individual who works for us who is at the initial point of engagement with federal law enforcement will have a list of what to do and not do. The consequences of making errors in that moment can be significant, and you want to make sure that it's planned out, that again there's a checklist, and that there's training for those things. So in terms of what you do internally, I would say be sure to have consistency in your process in terms of I-9 documentation. Also perform an audit. We're now doing it semi-annually, just because of the amount of turnover between summer, fall, and then again come winter, spring. And then making sure that your employees have something to use in case something happens. That's it.
I wanted to also mention, in these policies, have a trial run, especially when you're developing policies and protocols for when law enforcement shows up at your doorstep or in your lobby or in your place of business. It's important to have a trial run. If you have that designated manager point person, what is that point person going to do? What steps are they going to take? How are they going to escalate it to another manager if things start to get heated? And it's super important to remember that it's a balancing act. You are trying to comply with a law enforcement action if there is a lawful enforcement action that's about to take place. We talked about the judicial warrants, and you want smooth operations for your business with minimal disruption. So what's very important is nobody's going to play hero in this interaction with law enforcement. So if they're coming to your business and they have a right to enter your business, they're coming for a specific purpose, and they may have a very lawful reason for doing so. So to the point that Connor made, you could document things, maybe you can videotape what's going on, you can certainly keep notes and write down everything that happened. So if something unlawful did happen, that's not going to be handled in that moment. It's going to be handled in a lawsuit. It's going to be handled downstream. Another thing that has come up in other presentations is given the complicated nature of the I-9 and employees are giving documents and, maybe it looks real, maybe it doesn't, maybe the laminate is coming off, maybe a picture has been slid in. Like, what level of law enforcement do I, as an employer, need to play? So it's important to know that the standard is reasonableness, but if you see a document that is clear on its face, something that is, bizarre, not right, fonts are different, it doesn't look like a government document that you've seen before, there are ways to verify that, again, through your employment lawyer, your employment immigration lawyer, or you could reject it if it's a reasonable rejection and tell the individual to come back with other documents. But the flip side of that is you are not law enforcement. So if people are presenting what appear to be real documents to you, and you're completing your I-9, and then there's an audit, and they flag those as not legitimate documents, you will be able to take action on that and ask the individual to get other documents in a certain amount of time. Otherwise, employment will end. But if you in good faith did that, and it's not every single worker that you had this situation, then it will be an outlier and not sort of a pattern in practice.
And thank you so much, guys. That was such great, timely information. And just a reminder, if anyone has a question, please post it in the chat. Dominique, did you have any closing thoughts you wanted to share?
No, I just would like to thank you all for joining us. Thank you for that wonderful presentation. It was great seeing you again, Connor. Wonderful as usual. Teresa, thank you for the partnership and all of this great work. You gave us a host of information. I'm assuming there aren't any additional questions. Nobody dropped in last minute. Any questions? All right. I think maybe you all just gave us a lot of information to just take back. You were so thorough. No one had any questions, so that means great job. So we appreciate you all and all that you're doing. You all put up the contact information if anyone needs to get in touch with you after this meeting. We will be posting this meeting, I believe, on our YouTube page if anyone has any questions afterwards. So continue to stay connected to the source and all of our webinar Wednesdays, as both me and Mercedes stated. We are holding these on the last Wednesday of every month. Stay tuned. We have more to come. Next month, I believe we're doing our solar synergy. Is that correct, Mercedes?
That's the intention, yeah. So please join us the final Wednesday of the month. Our webinar Wednesday will be introducing kind of the Solar Synergy program, and then our partners through the source, our new BSO actually, Builders Avenue, will be sharing some very relevant and exciting information. So please join us.
Yeah, always great stuff going on here. So please stay connected. If you all need anything, you know how to reach us through the source, Cook County Small Biz. If you need any assistance in food, please do reach out to our wonderful partners, Illinois Restaurant Association. We have Teresa here to assist you all. And again, thank you all. Thank you. And with that, I believe we have some time to give you back. Have a wonderful day, everyone.
Thank you.
Thank you.
Bye-bye.
Thanks, Amir. Thanks, Michael. Have a good one. Bye.